Okay, guys, what we were talking about was the Canvas thing, and some of you guys still can't get on this Canvas to take the quizzes and stuff like that. So I spoke with Miss Mallon about it, and she said it's something about syncing your computer or something about syncing ACEs to Canvas. And there is something, it's a simple little process or whatever. So, actually, you know what, I'm going to email her the information.
Stephanie, did you see it? The quizzes and everything?
Yeah, I've got it on my phone.
We have to do the assignments too.
Yeah, you're supposed to.
Yeah.
You're supposed to, because it'll help you.
Like you want us to turn them in or just do them?
No, it's just for you guys.
Okay.
It's just for y'all, so, you know, it's not something that,
A few of these chapters are going to be.
and I know that,
Speaking of.
you know, that some of you can get into the master. And I think it actually shows the,
I started to bring you to, I had to.
the final.
Huge.
I don't know if you can get in there that it shows you the final, but that's not gonna be the final anyway, so it doesn't really matter, okay? But most of that stuff that you really need to go in there and kind of do the quizzes and stuff like that. So if for some reason you're still not getting it, let me know. Miss Mallon, and I text her the information, but she's gonna try to sync it herself. And, you know, I guess she knows how to do it. And if for some reason, she's not gonna be here tomorrow, she wasn't gonna be able to do it today, she's not gonna be here tomorrow. So she said by Friday. So by Friday evening, you still can't get in it, then text me and let me know, hey, you know, I still can't get in Canvas or whatever. Okay? If not, then I'm gonna assume that you can get in it. Okay?
So do you want the people who have access to the master to start already or wait till?
Yeah, no, go ahead and start. I mean, if you can get in and start doing this, yeah, start doing them. Yeah. Is most everybody, can most everybody get in? You can?
No. I have
Well, I
access
know
to,
you
there's
can.
no content. It's
Yeah.
like,
What's that?
yeah, there's no content. So when I click on the quizzes or the other things, there's
Oh,
nothing
there's no
there.
content,
just
okay.
everything blank,
So
yeah.
it's not published.
Right.
Right.
Okay, all right. Okay, well then, like I said, if by Friday evening or whatever, it hasn't gone through, then let me know, okay? All right, chapter 6, a typical criminal jury trial. So the objectives are to define and explain the various steps that are involved in a typical criminal trial, explain differences between a criminal trial and civil trial, explain the difference between a grand jury investigation and preliminary examination, discuss the coroner's inquest, explain how the jury is selected for jury trial, explain what the opening statements by counsel are, explain the differences between direct examination, cross-examination, redirect examination, and recross, define voir dire, explain the differences between rebuttal and surrebuttal, define the testimony by deposition, explain a bench conference or sidebar, describe a jury visit, what the closing arguments by counsel are, what is meant by the court's instruction, explain the jury's deliberation process and how a verdict is reached, and what is meant by directed verdict and special issues. Okay? All right. A criminal matter is one that deals with the person who breaks the law. You guys know that, right? As opposed to a civil. Okay? He or she has committed a transgression against the laws of society and is held accountable for his or her actions. A crime may be classified as either a felony or a misdemeanor. A felony is a crime that is considered more serious than a misdemeanor. A misdemeanor crime is considered a lesser offense. The difference between a criminal and a civil matter is in terms of the parties to the action and the redress sought as a result of the litigation. So generally in civil matters, one person brings the action against another person for a wrong, okay? So it can be a car accident, slip and fall, divorce, contract dispute, all kinds of stuff, okay? So it's not things that you're really gonna go to jail for, you know? So really what they're gonna do is they're gonna sue you probably for monetary stuff or for possessions in a marriage, children, stuff like that, okay? In a criminal matter, a person who represents the people of a community, county, state, or nation brings an action against a person who wronged them by breaking the law. In a civil matter, the form of redress is financial, attempting to make the person who is wronged whole again by means of a monetary reward. Okay? We just went over that. So 1, a person is protected from unreasonable search and seizure. Search and seizure. Search and seizure, okay? So that just means that the government can't just come in and do what they want. They have to have probable cause to come in and do it, okay? So they can't just come in and do an unreasonable search and seizure. Persons accused of serious crimes must be brought to trial only after an indictment by a grand jury, except in state prosecutions, okay? So like if you're accused of domestic violence, they don't have to get a grand jury to come in or whatever. If the state picks it up, then they can pick it up and go with it, okay? No person shall be put into jeopardy twice for the same crime. So you can't be tried and it's like, they found him not guilty. You know what, we're gonna try him again in front of 12 more people because we know that he did it, and we're just gonna keep doing it until somebody finds him guilty. They can't do that, okay? So you get tried once, and once it's done, then they can't do it again. A defendant is not required to testify against himself or herself. Y'all know that, right? So, they can bring, you could have shot up a mall, and everybody saw you, whatever, but it's like, it wasn't me. It wasn't me. The state has to bring all those people in and prove that you did it. Not that you get on the stand and, prove to them that you didn't do it. They have to bring people in to prove that you did do it. No one can be deprived of life, liberty, or property without due process of law. Absolutely. Indicted persons are entitled to trial by jury and assistance of counsel, and to be confronted by prosecution witnesses and to have witnesses in their favor. Okay? So they can't just say, well, he robbed that store. That's all we have. So convict him. No. Okay? And I'll tell y'all a funny story. I got picked on a jury last year. And so, we're in there and it's like, well, what's it for? Whatever. Well, it's possession. So, okay. So this guy, it's raining. So this guy's going down and he runs off the road. Runs off the road, whatever, so he's stuck. So a policeman comes, and asks him, he goes, hey man, are you all right? It's pouring down. Hey man, are you all right or whatever? Do you need any help? Yeah, I need some help.
Oh boy.
Idiot. Yeah, I need some help. Okay. So the guy goes back to the car or whatever, and the police officer for some reason thought, you know what, something's just not right. I'm going to run this plate or whatever. So he runs a plate. Car comes back stolen. So he tells the guy, hey man, you know what? If you can, put your hands behind your back. I need to put you under it. Well, yeah, the car's coming back stolen. Okay. Looks in the car. There's a stolen TV. There's some other stolen items. Checks the guy, and he has like 18 bags of heroin on him.
Oh my God.
Checks the car and finds this duffel bag with like 89 bags of heroin. So now, let's go.
Yeah.
So they go down. So it's like, it shouldn't be that hard. Whatever. So it's like, why would you even be fighting this? Whatever. So the defense attorney gets up. He said, well, what we're going to show is that the officer, instead of taking the bag to the evidence room, takes it to the property room. So all of the stuff that they found, he takes it to the property room. So like when this guy bailed out, he goes and picks up his stuff and he was gone. So they don't have any heroin. They don't have any of the stuff. All they had was the stolen vehicle from a buddy of his, and all they had was the video inside of the car where the guy still had his phone on him. The cop didn't even get the phone out from the guy. He made a call from the back seat of the car with his hands behind his back. You don't teach that. That's learned. That's good stuff right there. You don't teach something like that, you know? And this guy made a call and he said, hey man, I just want to let you know that the cops picked me up or whatever. If you can, you need to come pick up your car. I stole it and stole your TV and some other stuff, and it's over here off of blah, blah, blah. And then hangs up the phone. So I'm like, you know, what? So the state's like, yeah, we're going to bring in the officer that said that he found the stuff. You don't have anything. Zero. They didn't have any evidence. None of the drugs or anything was they had. None of it in evidence to prove it. So it was like, and the judge is like, no. So we kept having to go in and out because they kept messing up or whatever, and they said, you know what, they ended up working out a deal, and they worked out a deal. So your time here is, but we spent like a day and a half going in and out of the courtroom or whatever because of stuff like that.
Wow.
But they didn't even have anything. You know, and the state wouldn't drop it. But yeah, so I think the guy got all of his heroin back, so it worked out well. So, beginning of a criminal trial. The wheels of justice are put into motion when a person has committed a crime. The person who commits the crime may be arrested and then arraigned, after which a preliminary examination may result in holding the person over for trial court, or a grand jury may investigate the facts surrounding it. So they can't just arrest you and just leave you in there. They have to bring you to court to find out, you know, if there's even probable cause to even keep you in there. Grand jury investigation. As noted previously, a grand jury is selected from the citizens of a community. Yeah. Usually a county within the state, for the purpose of investigating and determining whether sufficient evidence exists to charge a person. The grand jury members consider all business brought before them by an elected public officer, who may be called the prosecutor, the prosecuting attorney, or the state's attorney. So it's always the state that's bringing, you know, whatever against somebody else. So they're the ones that are proving it. The grand jury is then instructed as to the law and their duties and responsibility by the judge. This jury charge or instruction to the jury is given at the beginning of the investigation rather than at the end. The court reporter normally reports his charge, but is not usually transcribed. So it's just taken. So if they ever need it, they're like, hey, you know, remember when we indicted that guy, we're going to need that. Okay. But it's very rarely asked for, but it's always taken down.
You mean the entire transcript with the grand jury?
It's just
Or
the grand jury
jury
indictment.
charge? Okay.
It's just the grand jury indictment. And it kind of gives you some examples in figure 6.1 A and B, okay? When a grand jury decides that conclusive evidence of guilt is sufficient to try an individual, an indictment is issued. An indictment is the formal means of charging a defendant with a crime after an investigation by a grand jury. So that's the main thing that says, you know what, there is enough proof to try this guy. You're innocent until proven guilty, so it doesn't really mean that you did it. All they're saying is there was enough evidence to bring you to trial, and that's what the indictment is. Another name for an indictment is a true bill. If jurors find that sufficient evidence does not exist, an indictment is not issued. Very often the grand jury sees fit to issue a series of sealed indictments that charge a person with a crime, but they do not release the name of the individual until the proper authorities have arrested him or her, at which time the indictment may be opened. Did you say that y'all never turned a case down when you were on there?
Never. We had some sealed indictments too, but I can't remember the exact details. Why I'm sure was worried about. I don't know. I can't remember why. We did have a few sealed indictments.
Okay, preliminary examination. A justice of the peace, a judge, or a magistrate presides over a preliminary examination. This is a hearing held to decide whether sufficient evidence exists to order an accused person to be held over for trial in a higher court within the jurisdiction. And that's what I was telling you. This is the preliminary examination. When they bring you to court, you know, they've arrested you for something. They have to bring you to court and say, look, this is what we found. We found the heroin, but it's gone. Really? You know, this guy, and I couldn't believe this because this guy was in jail for like 45 days. So it kind of goes against what we're talking about right here. But I guess, well, they still had the stolen car, and I guess they had some of the, you know, they still had the stolen car. So I guess, you know, maybe that was it. Maybe that's what they were going on, you know, whatever. So I don't know. I don't know what they did. If sufficient evidence is presented by the prosecution in a preliminary hearing to indicate a probable cause to believe that that person who is the subject of the hearing committed the alleged crime, he or she is bound over to face trial. Okay? So that's what that is. The coroner's inquest. Reporters may also be called on to report other investigatory hearings that will result in the formal charging of a defendant with a crime. The coroner's inquest is called to determine the cause of death whenever foul play is suspected in the death of a person. Okay? In some states, the inquest is automatic when a person dies for no apparent reason. So really, it's just kind of a fancy
Like an
word
autopsy.
for autopsy. That's all it is. My lovely assistant just helped me. You just man the camera. I'm just kidding. So that's really all it is. It's just a fancy legal term for autopsy, okay? So when somebody just dies, you know, they're just not like, well, he just died. You know, and come to find out somebody shot him with so much heroin that it killed him, you know, because they needed him dead because maybe he was going to be a witness for something, you know? So, yeah, there's crazy things. If you sit in court long enough, I mean, you hear some really crazy stuff, you know, witnesses disappearing, witnesses forgetting, you know, so things happen.
No court reporters disappearing?
That's a great question.
Yeah, I don't think so. I don't think. I had a guy approach me one time and he's like, hey, you were that court reporter that took my termination hearing. Yeah? Oh, man, that wasn't right. Look, dude, I just took it down. I didn't render it or whatever. You know, I just took it down. I'm not that guy, you know. But I know where he lives, and I'll take you over there. No, but I mean, he wasn't coming up to be combative or whatever. He was just like, yeah, you were that guy. Yeah, remember y'all terminated my rights? Oh yeah, like you're the only person we've ever terminated. We terminate one person every week, you know. But sometimes, I mean, you don't forget faces of people, but it's kind of funny. I think I told you all that time that one of my old judges took his son to Taco Cabana. Yeah. They're like, hey, you know, they had already ordered and he's getting ready to get the food or whatever he's paying, and hey, you were the judge that terminated my rights. You're Judge so-and-so. He goes bailing out of there, so, yeah. So you see some people every now and then. An arraignment is a hearing to which a person accused of a crime is brought before the court to enter a plea to the charges contained in the counts of an indictment or complaint. So the purposes of arraignment is to allow the defendant to enter a plea, to exercise his or her constitutional rights, and to be allowed to be set free on bail if the court so deems. So if it's not, you know, that big of a deal, you know, it's DWI, possession of marijuana, stuff like that, more than likely you're going to make bail and, you know, you'll get out. If you shot up a mall, you know, and there's, you know, several people dead, you're probably not going to get out or whatever, but, or they're going to set your bail so high that you're not going to be able to get out anyway. But that's what that hearing is called, the arraignment. The court reporter is responsible for recording what happens during the arraignment proceedings. If the accused pleads guilty, the court sentences him or her, either immediately or at a later time. All pleas and sentences must be recorded by the recorder and transcribed. Yeah, because they can come back and say, well, you know, I never got charged for that. And that's why you keep it 12 years to 15 years. That might be, I think I told you I'll write that down on how long.
How long?
Yeah, so that's gonna be one thing to ask the reporter whenever they, you know, come. Sentences are reported verbatim, making sure that different sentences for different counts are recorded properly. Record whether a sentence is to be served concurrent or consecutively with other charges. Concurrent sentences are served at the same time, whereas consecutive sentences are served one after another. So let's just say, you know, a guy goes in and he kills his girlfriend and her mother and gets tried for both of them. Well, he can get tried, and if it's concurrent, then they're going to say, you know what, we're going to give you 45 years. Well, you serve 45 years. In state jail, I think it's like 2 to 1. So for every day that you serve, you get 2 days. So for 45 years, you're going to be in there like 22 and a half years or something like that. Federal is day for day. So you get 45 years, you're doing 45 years. Okay, that's a difference. And then consecutive or stacked means, you know what, we're going to give you 45 years on each count. Well, now you're serving 90 years. You know, so now you have to serve one term and then you have to serve the other term. Okay, so that's the difference. If the defendant pleads not guilty, a trial date is set and the prisoner is kept in jail, released on bail, or released on a personal recognizance. To be released on bail, the defendant must raise money or provide a property bond and leave it with the court to assure that he or she will return to stand trial. To be released on one's own recognizance is to be released with the assurance that he or she will return to stand trial. Sometimes in the case of a minor defendant, the person may be released in the custody of another person, such as a parent or a guardian. In some courts, before the trial is to be held, a pretrial hearing or pretrial conference may be heard. This hearing helps to simplify the issues, amend the pleadings, obtain admissions of fact, limit the number of expert witnesses, make motions, or otherwise settle the case and agree on damages. Selection of the jury. Every person has a right to a trial by jury. In civil matters, that right may be waived, and in criminal cases, the defendant may waive his or her right only in some states. Some states require that all defendants in felony prosecutions be tried before a jury. I don't think that's the case here. That would be another question to ask. So don't write that down. Write that down. So that's going to be something to ask them. I don't think it is, because I think you can be tried before the judge. Before a judge, okay? I'll tell you a funny story. I sat with a judge on the criminal side, and it was a guy that, it wasn't for murder, but I think that he had done something pretty bad, and he was a repeat offender or whatever. So the judge gave him like 25 years. And this guy, you know, big old guy, you know, pretty tough looking guy or whatever, I mean, just starts crying. And he's like, Judge, I can't do 25 years. He goes, you can't? No. He goes, well, can you do 1 day? And that guy's face lights up and he goes, yeah, I can do 1 day. He goes, good. Do 1 day at a time. You should have seen that guy. It was like you know, but I mean, you know, you get to the point, and it's not making fun of these guys, but it's like, you know what? You know, if you're going to do the crime, you know, you pretty much have to do the time. So,
Yeah.
you know, and this guy was just like a repeat offender, so. The first step in a trial by jury is the selection of the individuals who will make up the jury. Usually the process begins with a panel of jurors who convene in a court which the case is to be tried. Prospective jurors are selected according to statutory and constitutional provisions within each jurisdiction. So like I was telling you guys, for a county court case, it's only 6 jurors. You only have 6. But for a civil district matter or a criminal matter is going to be 12. Okay? And depending on the offense is going to determine how big the jury panel is. You know, so like, you know, if it's like a possession of marijuana, then they may have maybe 40 jurors go in, and then they just pick 12 out of the 40. But if it's like a capital murder, you could have 100. And it could last, I mean, I've heard it lasting up to like a month. That'll be another question to ask. You know, like on a criminal murder or something like, I mean, a capital murder or something like that. You know, and they'll go through and ask these guys, you know, really in-depth questions. And like when it goes up, like when somebody's convicted of murder, it automatically goes up on appeal. They don't have to appeal it. I think it automatically goes up. So that's going to be another question to ask the reporter, you know, because I think it automatically goes up. You know, so you can be sitting there for 2 or 3 weeks taking voir dire, and then the trial itself lasts a month. So now you're 7, 8 weeks into this trial, and then it's like, yeah, he got convicted. You know, he got life. Okay, well, start typing it up. 40 to 60 pages in an hour. 6 to 7, maybe 8 hours a day. In 2 months. You know, 8, 10, 12,000 pages, 15,000 pages. Yeah, so it's crazy, okay? So some of these girls on the other side stayed extremely busy, extremely. And it's not like mine. Mine was different. Mine was busy, but mine is 10 days. So I had 10 days to get it out. They'll have like 180 days to get it out, but I mean, you're talking about 12,000 pages to get out too. So it's a little bit different. So that might be another question to ask them, exactly how long they get, you know, and then you can file for an extension and, you know, stuff like that too.
I have a question. Can you just go over how many jurors again? That was one of my questions.
In
Is it
county, it's 6.
For county? Okay.
6 for county, and it's 12 for district.
District, okay.
Yeah, or criminal. So any of the district courts are going to be 12. All of the county, usually the county are 6.
Because it's smaller?
Yeah, and it doesn't involve like larger, you know, like in some county courts, I mean, you can only sue for like so much. Once you sue over that amount, you're going to sue somebody for, I don't even know what the steps are on it. I think it may be like 10,000. Anything over 10,000, then you go to like a district court. So it has to do with that.
So these reporters that have these huge giant cases, they can't ever say, no, I can't write anymore this week because I got to do this transcript. They have to keep going. Correct.
Yeah. So sometimes, you know, if they have something that comes up, I mean, they can get somebody, but I mean, it's, you know, the judge pretty much keeps it in the record. You know, well, Elizabeth did the first 2 weeks, and then she got sick or whatever, then Elisa came in, and then she did a week, and then Elizabeth came back because it's her court, so she came and did 4 weeks, and she got sick again, you know, whatever, and then, you know, Rosa had to come in, and she did 2 weeks, and then, you know, Elizabeth came back, and it's like, what?
Why didn't they ask me back?
I saw you right. So, no, I mean, it's just kind of the pool. I mean, so like if you're not in that court, then they just get a person who's available. So, you know, and the judge may request, you know what, Elisa took 2 weeks, you know, and then Elizabeth got sick again. So, you know what, I want Elisa back because she took some of it. So I want it all to be the same. They didn't want it to be 5 different reporters on a 2-month trial. Does that make sense? So like you said, in their 2 weeks, they could have just said, you know what, we just need you for a week, but this other reporter is gonna come in because she's available, and we kind of wanted to give her, no. Usually in something like that, they try to keep it consecutive, okay? Attorneys will examine the prospective jurors as to their qualifications, lack of prejudice, and general knowledge and understanding, which is called voir dire examination. Voir dire is a French term that means to speak the truth. The attorney may challenge or excuse the prospective jury members either for cause or peremptory. That is, without cause. So, like I was telling you guys that, you know, I got struck as a peremptory strike. They don't have to give a reason. You know what? I don't like it. You don't look like you can be fair. But they don't even have to tell the judge that. You know, and I think I told you guys when I approached the bench or whatever, the judge is like, why are you striking that? He said, Judge, I don't have to give a reason. I'm using one of my, and I think they get 5. I'm using one of my 5 peremptory strikes, and he's one of them. So, adios. In some jurisdictions, court reporters must report everything that occurs during the voir dire examination. In most other states, a judge will call the court reporter only when required. In capital cases, the official court reporter reports everything. So in a capital case, they're going to report everything. You know, and if it goes up on appeal, then they type everything. Okay? If the matter is a felony offense, a reporter will usually be requested to take the voir dire examination, which must be completely accurate. After a verdict is reached, counsel on either side has a right to subpoena the entire jury and have them return to court. At this time, questions are asked about what happened in the jury room. Attorneys will request that the official reporter transcribe the voir dire examination to see whether any irregularities occurred in what was answered. So, I mean, you know, if they're just there, you know, you're not supposed to deliberate in the case. You know, most of these guys are like, man, let's start deliberating now because I don't want to get to the end and, you know, we're here another week, you know, because we've been here 2 months or whatever, and, you know, I want to start figuring it out now. Well, you're not supposed to do that, okay? Or, you know what, hey, man, I talked to the defense attorney, and he was saying that his client didn't do it. It was his brother, and he's taking the rap for his brother or whatever. Now it's a mistrial. So, I mean, they can find out, you know, things like that. So, before the attorneys begin questioning the veneerman, the prospective members of the jury, they often make a few introductory remarks. These remarks are not the opening statement of the attorneys. Sometimes the entire jury panel is seated in the courtroom and questions are asked of the whole group, with responses from one or few prospective jurors being given. In this case, a reporter often has no way of identifying the particular jurors unless the attorney calls them by name or the reporter knows them. Therefore, if the reporter is taking down the voir dire examination, the jury members will be designated as prospective juror. Well, they give you a number here in Bexar County. So they give you a number. So, I mean, they'll ask you, okay, of you guys, how many of you guys are Catholic? Okay, number 1, number 3, number 16, 18. So they're saying this out loud. So, you know, the court reporter's taking it down so they know which juror it is. Okay? And of you guys, how many of you guys have or know somebody that works for some kind of police department? Number 1, 13, 18, 22. You know, so they're saying it out loud or whatever. So when it comes back or goes up on appeal, then they know, you know, kind of what's going on. Okay? Which is what they're talking about over here. can be designated as a prospective juror, or preferably by the number assigned to them when they are called forward, as in prospective juror number 3. So they don't say juror 3, juror 4, because you're not on the jury yet. It's prospective. Okay? The attorneys for either side can excuse prospective jurors. Jurors are excused by the exercise of a peremptory challenge or a challenge for cause. Each party is allowed an unlimited number of challenges for cause, which are challenges for which some reason is stated. For example, if a prospective jury member turns out to be related to one of the parties in the action, he or she would be excused for cause. Okay? So, I mean, if you go up there and, you know, and you see it all the time, you know, these guys don't want to serve on juries, they want to be gone. So, you know, you have these clowns that go up there and they're like, well, you know, if he's accused today, can we, you know, fry him today? And yeah, he's out. You know, and just, you know, everybody's always trying to look for a way to get off, and, you know, and they'll find ways to get through it. You know, and these attorneys and judges have faced it enough times that, you know, they're not gonna, you know, just let you get off. You know, but if it's like, you know what, you know, I believe that policemen just have the right to shoot people just for no reason. Judge number 3, you know, and stuff like that. And the guy truly believes, I mean, you know, hey, you know, if a cop is put in a situation where he pulls his revolver, then he should have the right to shoot someone. No, no. You have to have cause, you know, to be able to do it. But this guy or, you know, woman truly believes in, you know, so you can be struck for cause. So it's showing a cause of why they should. The peremptory is just like, I want 3, 5, 8, 15 gone. Those are my peremptory. Okay. And you don't have to give a reason whatsoever. They don't have to give a reason. The number of peremptory challenges is set by a statute depending on whether it is a civil or criminal matter and depending on the number of jurors to be selected. A peremptory challenge is a challenge for which no reason has to be given for excusing the juror. The reporter should keep track of the challenges made and chart the jury as it is seated.
Does that mean that a lawyer could ask you how many of?
I think usually the judge keeps track of it. I don't know. I mean, it had been so long since I've taken a jury trial that I don't know. That might be another question that you ask the reporter, whether they keep track of it or not. I don't remember keeping track of it, but another type of challenge occurs when an attorney makes an objection to the entire panel of the prospective jurors. This challenge is called challenge to the array and asks that the entire panel be excused and that a new panel who more closely represents a group of peers be selected. For an example, an attorney representing a Native American or an African American person may challenge an entire panel if no members of his or her particular ancestry or heritage are on the panel. Yeah. At times, a jury may be sequestered or secluded in hotel rooms overnight. To sequester is to isolate or to segregate from the public. So like on this, you know, on the real big capital murders, yeah, they go to lunch together. They all go to lunch together to the same place. And they're escorted by the 2 deputies. They stay in hotels together, in the same hotel. The county picks up the tab and they stay in there. So, I mean, you're away from your family. I think you're able to go home on the weekends, I think. But like during the week, you're not. You're not supposed to talk about that case at all. 0. You know, they'll come in and, you know, that Monday it's like, did you talk about that case? Did you see anything on TV? Did you, you know, no, okay. You know, so it's, to be sequestered is pretty important.
I mean, so in a situation like that, then they can't be watched if they're sent home over the weekend. So more than likely they're not sent home, right?
No. You know, so that'll be another question to ask, you know, whether they get to go home on the weekends. You know, like the OJ trial, I'm almost 100% certain that they were sequestered. You know, and the one that I was telling you about where the venue was changed to Victoria, they were. You know, but it's funny. I mean, if you ever go down there to the courthouse and you see the bailiffs, and they've got, you know, there's one bailiff here and he's walking, and then there's 12 people behind him, and then there's another bailiff. That's what it is. It's a jury. They all sit in the same place. Their meals get paid for. So I mean, you know.
So, but they're not allowed to do anything, right, as far as watching TV or reading newspapers?
No,
Just gotta sit, I mean,
you just have to.
sit
I don't
there.
know. I mean, if you can read books
Read a
or
book,
you know
yeah.
what they do, you know, what you're allowed to do. Like get on the computer. I don't think you're allowed any of that. Like a radio, you know, maybe like a one of those MP3s or whatever. I guess, you know, if you have music downloaded, you can listen. I guess. I don't know.
So-
That'll be something to ask.
So if
the-
a juror does one of those, will they, and they're the reason for a mistrial, will they be penalized?
It could be. It could be. You know, like the first time, it's like, you know what, Judge, I went home and I was watching Judge Judy on Saturday, and, you know, all of a sudden, you know, the thing for the news came on early, and it just said, you know, hey, you know, this guy's on trial, and he's, you know, convicted of killing these 12 people at the mall, and that's the case that he or she's on. Well, I mean, I saw it. Well, you didn't really hear anything or whatever, but, you know, we asked you not to watch TV, so you may get, you know, hey, don't do it again. You know, you may get one of those. But sometimes they'll have like 2 extra jurors. So if something happens and somebody has to be
Right.
excused, they're not gonna repanel, you know, another 12. They're just gonna take one of those, God, I forgot what they're called. It'll come to me in just a second. But it's like 2 extra people
And
that are
they're
on there.
sequestered also, even
Oh,
though.
yeah. And you sit there and you listen to the evidence just like everyone else.
We had alternates even for that.
Is it alternate? Is that what it's called? Alternate juror? Yeah, it might be an alternate juror. Yeah. So just in case. But then you get to the end and nobody got struck or whatever, then you're just like, well, you just sit here. You get to sit in there with them because if something happened, it's like, hey,
Right, you hear.
Mary Jane over there was in the bathroom and 2, you know, attorneys were talking about that case, and, you know, they told her, hey, you know, you need to, you know, vote this way or whatever.
But the attorneys get in trouble.
Oh, yeah. But if they talk to their juror, then it could cause a mistrial.
Right.
So, oh yeah, they're getting way in trouble. Yeah. Opening statements by counsel. After the jury has been impaneled and sworn, the attorneys from both sides of the case may make an opening statement to the jury. The purpose of the opening statement is to outline their theory of the case and tell the members of the jury what they should expect the evidence to show. So usually, I mean, by the time they get to trial, there's not supposed to be any smoking guns. They're not supposed to be, you know, and TV kind of elaborates some of this stuff a little bit. But I mean, usually it's open discovery, so they know exactly what they're doing. They know exactly what they're bringing. You know, the other side is able to question or depose the other one's witnesses to see exactly what they're going to come and testify about, so they know exactly what's going on. I mean, there's not usually a whole lot of surprises, you know, in things. TV kind of elaborates it a little bit. The reporter is not allowed to interrupt counsel during their opening statements. I've never heard that. And if I'm not getting it, and that guy's like, well, what we hope to prove is that the defendant came in and he was in this car and they went to the H-E-B and he grabbed 8 loaves of bread and then all of a sudden he pulled out a gun and he shot this guy. Really? That guy's going 350 words a minute. I'm stopping him. I can promise you, I'm stopping him. If I'm not getting it, I'm stopping him. But usually when somebody's talking that fast, one, if you can't hear it and get it, usually somebody else can't understand them either. And I just, you know, I've noticed that over the years. I mean, because like even my judge, whoa, slow down. I can't even understand you. I can't either. you know, and I was getting ready, yeah, and he beat me to it, you know, whatever. So usually, I mean, you know, it's real hard to comprehend when people are, you know, that flighty and, you know, whatever. So, I mean, you know, and then, you know, some people just are like that. They think out loud. You know, they're not thinking, you know, okay, well, I went to the store, and then when I walked in, you know, and, you know, like I told you guys, you can think at like 900 words a minute. So you're thinking of what you're going to say. Some people don't. Or maybe their minds just think at 1,500 words a minute. I don't know, you know, but they know what they're going to say, and they start rattling it off. I've never heard that. I've never heard that. So that may be one of the other questions to ask when the reporter comes. And guys, I better not get these guys over here and, okay, anybody have any questions? Okay, I guess I'll go. And then they leave and it's like, hey sir, when they asked about that thing, because you're gonna get it, right? When that camera goes off. So, I mean, that's why I'm telling you guys now. So, I mean, when they come, I mean, guys, these are great questions to ask, okay? The plaintiff's attorney represents his or her case first. The plaintiff has the option of waiving the opening statement. After the plaintiff's opening statement, the defendant may give his or her opening argument or wait until the plaintiff rests in his or her case. So the plaintiff always gives like an opening statement of what they're going to prove or whatever. And the defendant or the defense always has the option of I can't remember what I was saying.
Sorry.
Of not giving his or their opening statement, the defense's opening statement, okay? So they can go through and say, you know what, I want to hear what they're going to prove. And then they get to the end of their case, well, they can ask, and I'm sure it's going to come up, they can ask for a directed verdict. And a directed verdict, and I'm sure they're going to get into it later, but it's like, you know what, Judge, they didn't prove their case. And if the judge rules in their favor, then they don't have to put any evidence on, and the case is dismissed. So the state has to prove their case. So like in the case that I was sitting on with this thing, and they go through this whole thing, well, isn't it true you found this heroin in it? Yeah, and you found 80-some bags? Yeah, and there was a TV in a car that was stuck, and blah, yeah. Until the defense comes, well, where's that heroin? We don't have it. So you expect us to believe that you actually have it? Well, you know, it was there, but it's not there. Okay. You know, and then they get to the end, it's like, Judge, they didn't prove their case. They have no facts, no evidence of anything that was in there. So they could have said the guy had a meth lab. He was driving one of those things like Breaking Bad, that's pretty cool. One of those big old travel trailers or whatever, but now all of a sudden that travel trailer, you know, thing isn't here, and we don't have any evidence, but I promise, I took an oath, you know, really? No. And they say, you know what, Judge, we're gonna ask for a directed verdict. Granted. And I think that's what they might have done. I talked to the defense attorney afterwards, and he's like, they didn't have anything, Dave. I said, what? I mean, and they didn't get into it with us then, but I mean, he told me afterwards. He was like, so he told me the whole story, and it's like, oh my God, if we would have heard that thing, that would have been crazy. So, if more than one defendant is involved, each counsel will be given a chance to make an opening statement on behalf of his or her client. The amount of time allowed for each opening statement may be set in advance by agreement of court or counsel. Some judges require officials to report opening statements, even though they are not usually transcribed. So it's not evidence of anything. So opening statements aren't evidence, closing arguments aren't evidence, and you'll hear it. If you ever go sit in my old court, you know, my judge will say, you know, we'll hear a case and it was, you know, 4 hours. And he'll say, okay, I'm not a jury. Give me 30 seconds of what you hope that you proved. Okay, Judge, well, blah, 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 and blah, 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 and blah, 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 and blah. Okay, you got 10 seconds. And then blah, and blah, and blah, and blah. Okay, you have 30 seconds, go. he already knows. He's already heard the evidence. It's not, testimony. I mean, it's not evidence of anything. And sometimes the attorneys will stand up and they go, Judge, I object. They didn't mention anything about that kid having marks on his back or whatever. Like, you know what? It's closing argument. It's not evidence. And I'm the judge, so I know what I heard and what I didn't hear. So they can say whatever they want. So they can pretty much say whatever they want in closing arguments. Now the attorneys can object, but it's like, no. I guess when there's a jury, it's going to make a little bit more of a difference. But, the judge will tell them, in the jury charge, you're the judges of the facts, not the law. Closing
Right,
statements
right.
or
Hear that all
opening
the time.
statements and
Jury
closing.
charge, arguments,
Yeah.
yeah. It's
So
not
next time, pay
evidence.
attention in that jury charge and see if you hear it. Opening statements and closing arguments are not evidence and are not to be considered as evidence, blah, blah, blah. It'll come back to you. All right, the plaintiff's case in chief. After selection of a jury, preliminary motions and the opening statements have been disposed of, the plaintiff's attorney will present all witnesses on whom he or she will rely to establish the facts in his or her case and the physical evidence or exhibits that will support the allegations. So when the person bringing the lawsuit calls a witness, that's direct examination. Okay? Because they're the ones who called the witness. So it doesn't matter whether it's the state or whether it's the defense. When the defense gets a chance to put their side of their case on and he says, you know what, Judge, we're going to call the defendant's mom. Okay? Well, just because it's the state who has to prove their case, the defense is calling the witness. So whoever calls the witness, pay attention. Whoever calls the witness is direct. Okay? Everyone else after that is cross. And now it comes back to the defense. Well, Judge, I have some more questions according to the cross that the state had. So now it's redirect. So this guy is always going to be direct. Okay? So the person calling the witness is always going to be direct or redirect. Everyone else, and say there's 9 defendants. So they have 9 attorneys, and the state calls the officer who arrested all of them. We're going to call this officer. All right, that's direct. So they question the guy. Miss Elizabeth, you do cross. So she's the attorney for one defendant. You're the attorney for one defendant. She's the attorney for one defendant. She's the attorney for another defendant. He's the attorney for another defendant. He's the attorney. So now it's cross, 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 cross. Okay? For everybody else. The person who calls the witness is always direct or redirect. Everyone else is cross. Comes back to the person who called the witness. Judge, we have some questions according to the cross that they had. Now it's redirect. Anyone else have any questions? You know what, Judge? I have some questions according to what the state just asked. Recross. Everything is just recross after that. It's not further recross, recross, recross of the cross of the recross. No, it's just recross after that. Does that make sense?
Yes.
Is everyone awake? Yes?
Yes.
Yes. Okay. So that's what it is. Okay? So you should have learned that in the Eclipse class. You didn't?
I did.
You better have. You're going to have to go back and check that final. But that's what it is. Okay? And that's the setup right there. So if you haven't taken the Eclipse class, that's the setup right there. Is on page 50. So it's direct examination by Mr. So-and-so, question, boom. Okay? So during examination of a witness, opposing counsel may ask to conduct voir dire examination to establish competency or qualifications of the witness to testify concerning some subject or exhibit to prevent improper evidence from being placed in the record. So let's just say, you know, Danita? Danita? Danita's the witness, and I'm asking questions of Danita. Danita, I want you to look at these series of pictures. Okay, are these true and correct photos of the little kid that was abused? Yes, it is. Okay, Judge, we want to offer these exhibits into evidence. Boom. Judge, I want to take this witness on voir dire. Well, for what purpose? Well, she's not the one that took the pictures. Go ahead. So you start questioning Danita. Are you the person that took these pictures? No, I'm not. Who took the pictures? Well, my coworker took the pictures. So you didn't take the pictures. So you don't know if these are true and accurate pictures or if they've been photoshopped in any way. Well, no, I'm pretty sure the pictures, and that's the boy, that's the kid, and those are the end. No. You have to, in order to get like photos in of stuff, you have to get the person who took the photos. So that's voir dire examination, is to find out the truthfulness of the person who's testifying to try to get something in, some kind of testimony or whether it be an exhibit. Okay?
Would that be a motion,
No.
voir dire?
No. Voir dire.
Okay.
Voir dire.
But so if they find it, if they find that she lied, then it's just on record that she lied, she's not like dismissed or anything?
Well, and they can, it's called like impeachment. So they're trying to impeach the witness on their veracity. Judge, she said she took these pictures. Well, we had this other witness that came up and said she was the one who took the pictures. Oh, yeah, I didn't take those pictures. Well, now your credibility goes into, question. Well, can we believe anything she says? She says she took the pictures, not that hard. You either took them or you didn't. It's like being pregnant. Either you are or you aren't. I don't know, So, did you take the pictures? Didn't you take the pictures? Well, I thought I did. No, you didn't. So now your credibility goes, and so now they're trying to impeach the witness on, she can't even be believed. Who knows what else she was lying about. If she lied about taking the pictures, who knows what else she lied about. Okay? So that's voir dire examination. So that's how you set it up also. Voir dire examination by Mr. and Miss So-and-so, questions. Got it? Defendant's case in chief. Assuming that the judge denies the motion to dismiss the case, the defendant now presents all witnesses and exhibits to support his or her side of the case. So at the end of the plaintiff's case, the defendant or the defense or the respondent can ask, you know what, Judge? They didn't prove their case. We're asking for a directed verdict. You know what? No, I think they did. I think they did. Go ahead. Put on your case in chief. Okay. So now the defendant's case in chief comes in, and that's what they do. If defense counsel did not present an opening statement at the beginning of the trial, he or she may do so at this time or waive it altogether. Witnesses presented by the defendant's attorney are called on direct examination by defense and cross-examination by the plaintiff. Did you hear what I just said? Just what I told you guys earlier. So now it's the defendant's case in chief. Now he's calling the witnesses. Now he's on direct. Okay? So it's not because he's the defendant that he's always on cross-examination. Whoever calls the witness is direct. Okay? At some point, the plaintiff may now present his or her case in rebuttal. Pay attention. Rebuttal is confined to presenting testimony that will refute the evidence of the defendant. So now you have the case in chief of the plaintiff, defense case, and now the state or the plaintiff gets to come back and say, you know what, Judge, we have more evidence to contradict what they just brought in. We had no idea they were going to bring that in. Really? Maybe. But it's like, you know what? We didn't think we were going to have to use this witness because she took some pictures, but you know what? They talked about the pictures. Now we need to call this witness on rebuttal. Does everyone understand rebuttal? Yeah? Okay. Testimony by deposition. The deposition of a witness may be read into the record by the attorney who conducted the original deposition. The reporter may be furnished with a copy of the deposition, and the court may tell the reporter to record only objections and rulings concerning the depositions. When objections or colloquy occur, the reporter writes a material before the objection, the resulting colloquy, and the judge's ruling. For those of you that haven't taken my Eclipse class, do you guys know what colloquy is? Yes? No? Yeah. Okay. Colloquy is when the attorneys are just talking to each other, to the court, whatever. So it's not question and answer necessarily. And it could be question and answer of like each other. Well, did you serve me with that petition? Yeah, I served you with that petition. When did you serve me with that petition? So it's question and answer, but it's not, I want to call defense attorney as a witness. You can't call them as a witness. They're not witnesses. They're attorneys. Okay? So when they're talking like that, it's not question answer, even though it may be question answer. That's called colloquy. So let's see if there's a setup. Oh. Yeah. So on page 51, figure 6.4, you see how it's set up? Mr. So-and-so, Mrs. So-and-so. You see how it's set up? That's called colloquy. That's not question answer. Okay? But they may be asking questions and they require answers. Okay? But it's not question answer. That's called colloquy, and that's the setup of colloquy. Okay? Got it? So I don't know exactly what the rule is now, and we may need to ask some of the other, and I've taken it before, but it used to be like if they played a videotape deposition of a witness, you just kind of sat there. Sat there and, and then, you know what, Judge, I object. This wasn't, so now you start taking it because now they're objecting to the judge. The other side's, well, that's why we did it is because of this. And then, well, you know what, I ruled that that wasn't going to come in, so, we need to back it up or whatever. That's not going to be admitted. Now, I think you have to take everything. And I think that's on the uniform format rules, that you have to take everything now. Okay, so even if it's a tape recording thing, and they're like, we're going to play this tape recording thing, and the judge is like, all right. And I had to do that.
You write down the tape recording, what's being said?
Yeah, on the tape recording.
You wouldn't,
How did
really?
you?
Yeah,
Because there's a transcript for it.
yeah,
You're writing down.
yeah.
Okay.
And it has something to do with the fourth court. The fourth court was like, well, we want it, when they appeal it. The fourth court of appeals, when they appeal it, it's like, you know what, we want, what was said and what was actually
That's a
on
lot
there,
simpler.
and not the tape or whatever. Because, my opinion, maybe not right, but they don't want to have to fast forward through this tape, so they'll just read the thing. Really? So now we have to sit there and take it. Even though it's on videotape, it's on a hard copy, whatever. Yeah.
How do you set that up in your transcript?
As, videotaped deposition of Dr. So-and-so, and here you go. Not fun. Not fun. Okay? If a copy of the deposition is not furnished to the reporter at the judge's discretion, the reporter may or may not be requested to record the reading of the deposition. Yeah, well, possibly. Bench conferences are sidebar. The reporter may be called to the bench to take material outside of the hearing of the jury. Such bench conferences or sidebars may or not be included in the record. Whether a sidebar discussion is recorded is up to the judge. Absolutely. So, a lot of times, back in the day, we didn't have these sophisticated little microphones or whatever, and, whatever. So you just had to pick up your machine and go up there, and then you're sitting right there by the judge, and you're taking all this down. So you have that little thing where you just twist your machine off, and you just take your machine, and there you are writing on this thing. And you're up there, listening to these guys outside of the presence of the rest of the people, the parties, and the jury or whatever. Yeah, it used to be crazy. Now, we have these little microphone. I guess it's like a little microphone or whatever that records everything, that picks it up, So all you do is put this headset on, and now it's really loud. You can hear everything, and they're up there and they're like, Judge, we're not going to be able to get that testimony in because this guy, they didn't release him and he wasn't on the witness list or whatever. Well, we're going to allow him because blah, blah, blah. Well, they can't hear. They're talking to each other, and you can hear it just like I'm talking right now. Just like this. It's so amplified, and all you have to do is turn up the volume on your little recorder or whatever, and it just, we're not gonna about it, it can get really loud. So if you turn it up too loud, it can get really crazy or whatever. But you put it on, and it's just like you're right there, just like they're talking right now.
It's on their shirts?
Huh?
Where's the mic that is?
No, the mic is up there.
Oh.
You have it just on the bench. So really, it amplifies everything. So really, you can hear everything. You're sitting right here. The witness is here. The judge is there. The microphone, gets led up or whatever, and it's right there by the judge, in between, right in the middle of the judge. So if they come up there, it's right there in the middle, and everybody comes up there, and they're, right there in front of the judge. So that's where you want it. So you don't want it, if the table is, this long. I know you can't see it on the thing, but the microphone is set over here, and the judge is sitting right here, and everybody comes up, and it's like, oh, Judge, we're not going to be able to get that thing in. Guys, I can't hear because the microphone is over here. No. Set it up in the middle. All right? And if you ever go and sit in with a reporter, which you're going to need to for your internship, you'll notice that. Notice where they have the recorder. Okay? Jury visits. The court, on motion of counsel, may direct that the jury be escorted by court officers to inspect the locality of an alleged accident or crime, or to view a large piece of heavy equipment. The court reporter may be taken along to report the testimony at the scene. Yeah. I never did it, but I've heard of it happening. You know what, Judge? Well, they were on a construction site, and this maintainer actually backed up and ran over this guy, killed him. Now his family is suing, the company because this guy wasn't paying attention or whatever. Well, they can't bring the maintainer in. Well, did the guy go under? Those things are huge, and the tire and whatever. Well, we want the jurors to go out there and, to the site and see exactly where it happened. And well, he had an obstructed view, and the maintainer was coming back. It was raining, and the guy was looking back, and unless you're there, you're not going to get the full picture of. So I've heard, it happening. Actually, I heard, funny story. A female friend of mine went, and they asked her to go on this thing or whatever. Well, this was back in the day when we had paper. So they were out like at an airport hangar. And they said, set up, whatever. So she's sitting there right there, and then all of a sudden this gust of wind comes through that hangar, and that paper's just, yeah. So luckily, y'all don't have to worry about that anymore. But it happened. Closing arguments. After both sides have completed their respective presentation of evidence, a summation to the jury or closing statements or final arguments are presented. In most states, the defense will give a closing argument first, followed by the plaintiff. never paid that close attention, I guess. But, I mean, like in ours, the state has a burden of proof, the state goes first in their closing. It's saying the opposite here. It's saying that the plaintiff goes first and the defense gets to close first. So that might be one thing to ask also of the reporter that comes in.
Okay.
The closing argument is a final opportunity for both sides to address the jury. The reporter may not be required to report closing arguments. It depends on the court. And it's true. I mean, they're not evidence of anything. It's not evidence. So, you know, some judges will say, you know what, you don't have to take it. Or you don't have to take opening statements. Most of them do. Most of them want it. The court's instruction to the jury. After closing arguments, the judge delivers his or her charge to the jury. The jury charge, also called the jury instruction, sets forth the principles of law governing the case being heard and the application of these principles in reaching a just verdict. The judge ordinarily prepares his or her charge, and the lawyers provide the court with instructions that they would like to be included in the charge. Guys, in some county courts, the court reporter does it. Yeah. So I'm going to try to get a county court reporter to come in, and that's going to be one of the questions to ask them. One about the jurors, two about doing the jury charge. The official reporter is usually asked to transcribe a copy of the jury charge for the judge's files. These instructions may or not be included in the transcript, depending on the request of counsel. Occasionally, the judge may need to give a supplementary charge because the jury may have sent a note requesting further clarification, or they may indicate that they are deadlocked. If the jury cannot agree and so inform the court, the jury may give what is known as an Allen charge or dynamite charge, which asks the jurors to continue deliberations and to try to reach a verdict if they can conscientiously do so. Okay? They say, Judge, you know what? We've been here a week and we can't come to agreement. We can't. You know, and it has to be unanimous. You know, like in a capital murder, it has to be unanimous. In like a regular one, I think it has to be like, I think it's 10, at least 10 jurors. Like in a civil case. That might be another question to ask. And then, you know, for like a capital, I think it has to be everyone, unanimous. Everyone has to agree. Jury deliberations and verdict. The reporter must note carefully the time when the jury begins its deliberations. Also record each time that the jury comes back into the courtroom and leaves it again. A proper parenthetical expression is inserted into the record. That's going to be a good question to ask too, okay, because I'm not exactly sure. Each note sent by the jury is marked as an exhibit, and proper parenthetical expressions must be included in the transcript. While the jury is deliberating, the court reporter must be on call and readily available to read requested material and to report additional instructions or the verdict. The reporter must record the verdict and the polling of the jury, if this is requested. The polling of the jury means that each juror is asked whether he or she individually agrees with the final verdict in his or her final verdict. Okay? So, you know, and I've seen it happen. You know what, Judge, we want to poll the jury. Guilty, 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 guilty. I wouldn't, what? Well, Judge, I didn't really want to go along with it, but I've just been tired of sitting here or whatever, so I just said guilty. No, that's not how it works. I didn't really think he was guilty, but I'm just kind of ready to go home. No, that's not how it works. So that's why they polled the juries, okay? Directed verdicts and special issues. After the plaintiff is rested, and again after both sides have rested, either party to a lawsuit may move for a directed verdict if it feels that the case is so one-sided that the judge should make the decision instead of the jury, or that only questions of law remain and the judge should decide them. If the motion is granted for a directed verdict, the court will dismiss the jury and make the decision based on the evidence. Okay? Sometimes a case is decided on special issues, and a directed or instructed verdict in the lawsuit is based on these issues. In this event, the jury is given a series of questions to answer, and only one decision can result from the answers. Reporting the verdict. All verdicts are reported verbatim by the official court reporter and are transcribed as part of the record. Any comments made by the court involving sentencing or further action must also be reported, as well as any exceptions made by the attorneys and any requests or motions made by the losing party. Sentencing may follow the decision of the jury immediately, or most likely it will be postponed until a later date. Usually it happens like right after, like, you know, say they found him guilty like on a Thursday. So you know what? He's guilty of capital murder. Okay. Well, you know what? We're going to start sentencing on Monday. Since it's Thursday already, you know, the jurors have been here 3 weeks, you know, whatever. I'm going to give them an extra long weekend or whatever. We're going to start on Monday, and the sentencing should last another week. So then they bring an all new set of witnesses to, well, you know what, this guy has a criminal record, and, you know, so now they can get in all kinds of stuff. So, any questions about that section? Covered a lot of stuff. No?
Who can ask for a readback?
That's for what?
Readback?
Oh.
Like, is it just the attorneys, or could a witness say,
Usually-
hey, can you, I want you to
Well,
read
sometimes
that, please?"
the witness will say it, and the judge is like, you know,
Okay.
pipe down. No, I mean, you know, if they argue enough, you know, so I didn't say that. Yeah, you did. Yeah, I didn't say that. Yes, you did. I didn't say that. Judge, I didn't say that. Can I have it read back? You know, sometimes if you make good argument about, you know, sometimes the witness can ask for it to be read back. Most of the time it's the attorneys. Okay. A typical civil jury trial. What is meant by the pleading in a civil trial, differences between the counterclaim and cross-claim, various motions that may be made before a civil trial begins, discuss what is meant by discovery as it relates to the civil case, pretrial conferences and pretrial orders, 17 steps that make up a typical civil trial, and discuss various activities that go on after trial has completed. The pleadings in a civil case. The complaint is the first pleading filed in a lawsuit. When pleadings are the formal documents that make up the litigation, the complaint is the document that outlines the allegations made by the plaintiff against the defendant. So that's the first thing that starts at. We already kind of went over this in, you know, in the other chapter or whatever, so. The summons is the legal document that accompanies a complaint and literally summons a defendant into court to answer the charges contained in the complaint. So the summons is what you're served with. You're served with the complaint, and you're served with the summons that says, look, you're being sued. The summons says, you're being sued, get to court next Thursday. That's your court date when you show up. The summons usually states that if the defendant fails to file an answer in the allotted time, a default judgment will be entered against him or her. Once a complaint and the summons have been served on the defendant, he or she is given the opportunity to file an answer in the complaint. So the answer is, you know, hey, I didn't do it. I didn't do any of this stuff. I don't know what the heck they're talking about. They need to come to court and prove, so I'll be there on that day, on Thursday, and they need to prove, you know, what the complaint is about, okay? The answer is the formal written statement in which the defendant states the grounds of his or her defense against the allegations made in the complaint. By law, the defendant must address every issue made in the complaint by either denying or admitting the allegations. So it's just pretty much as it says, it's the answer. You answer what you've been charged with. Counterclaim or cross-claims. A claim is filed by a plaintiff against a defendant for a civil wrong. The defendant, in his or her answer to the complaint, may file a counterclaim against the plaintiff. So somebody may, let's say you were going along and you stop because somebody's getting ready to turn right, so you're slowing down, boom, you get hit from behind. Oh my God, what the heck just happened? Oh, I don't know. So the cops show up, you know what, she rear-ended me, okay, whatever. Well, next thing you know, you get served with a complaint and a summons to show into court because this lady that just rear-ended you is going to sue you because she said it was your fault. It wasn't my fault. As a matter of fact, I have injuries because of that thing. Now I'm going to file a counterclaim against her because she was the one who rear-ended me. So now you don't have to be the one that files the suit initially, but you can file a counterclaim and say, you know what, it wasn't me, it was you, and now I'm going to sue you. So now there's a counterclaim, okay? The original defendant may also file a cross-claim against another party who by implication may be called a co-defendant or co-plaintiff. In essence, when a claim and counterclaim involve the original parties, the cross-claim involves co-parties who may be involved in the original litigation. If a new party is brought into the lawsuit, he or she is referred to as a third-party plaintiff or defendant. The third-party plaintiff files a third-party complaint against a third-party defendant. Another name for the third-party lawsuit is impleader. Okay? Pretty cut and dry. I mean, all they're doing is bringing somebody else into the lawsuit that says, you know what, she hit me, then somebody hit her, and then it hit me again, and now I'm suing all of them. So now there's like a third party in there, okay? Pretrial activities, motions made before trial. Before a trial proceeds in a civil action, various motions may be made by the plaintiff or defendant. If a defendant fails to answer a complaint within the required time limit as set by statute, the plaintiff may make a motion for default judgment against a defendant. A motion for judgment on the pleadings is made by either party for the judge to decide the case based on the allegations or defenses in the pleadings. A motion for a summary judgment is for the disposition of the matter, asking the court to rule in favor of a party on the basis that no genuine issues or material fact exist for the moving party to be entitled to judgment of the matter of law. So like say somebody files a claim and it's like, you know what, they don't do anything for like a year and a half. You got filed, I mean you got served with the complaint. I think you can even have like the summons to appear before court and then say, you know what, we're going to reset that and we'll let you know when the reset date is. Okay. So they sign off on a reset, whatever, and the guy never resets the case for a year and a half. Had that happen right before I left my other court, and this guy hadn't done anything on this case, and people got killed at this plant. I mean, and this guy, all of these people, there was like 2 or 3 people that got killed and like 3 or 4 people that got injured. Well, one of the guys got killed, so his wife was bringing this lawsuit, and then she just never did anything. Like 2 years, 3 years. So these guys brought a motion that said, you know what, Judge, we want this thing thrown out. They haven't done anything in 3 years. You know what? I mean, well, why haven't y'all? Well, she's been busy and, 3 years? She lost her husband to this thing. Everybody else settled out. They gave him a chance to settle the case, with a monetary thing, and she's like, no, we're gonna go ahead and sue y'all. And then never does it. And the case got thrown out. So that's what they're talking about there. Discovery. The process of gathering information for trial is called discovery. Discovery helps to clarify the factual and legal issues and preserve the testimony of a witness for trial. Basically, 5 different methods of discovery are used in courts of law. One is a deposition, interrogatories, request for production of documents, request for admission, and request for physical and mental examinations of a person. So 5 different ways that you can get discovery. The court reporter is usually involved in the first 2 methods, deposition and interrogatories. Okay? Pretrial conferences and pretrial orders. When a case is not settled outside court and is ready to proceed to trial, a pretrial conference may be held between the parties to the litigation in order to make certain that all information is correct and that both parties are ready to proceed to trial. In federal court, actions may include the initial pretrial conference that is held early in the litigation. The final pretrial conference is usually held several weeks before the trial itself. Among the activities that occur during the pretrial conference are stipulations between counsel and the authenticity of documents, the narrowing of issues, and the exchange of information so that trial may go smoothly. So they're going to agree, you know what, I know that we got 28 boxes of discovery, but you know what, all we need is just these 9. We don't need all of them or whatever. So we're going to stipulate that we're just going to use these 9, and the other 19, we're not going to need those or whatever. So we're not going to need all 28 boxes. We just need the first 9. Oh, okay. And then they go on record and say, so they can't go on trial and say, you know what, in this box, in box 27, we found that, whoa, judge, we need to approach a bench. And that's where they come out, judge, they stipulated, in pretrial motions that, they weren't going to talk about any of the other boxes. They talked about, just the 9 that we were going to use and not box 27, that had these things. Oh, yeah, you can't talk about that. Okay?
Do they have stipulations and depositions as well? Even before?
Yeah. And a lot of times, and I don't know, you'll have to ask the reporter that comes, because it's been so long since I've taken one, but you used to have to ask, is this going to be taken by the rules? Yeah, we're going to take it by the rules. Okay. Well, the rule was that if you ask a question, and you can only make objections to certain things, the form of the question
Okay.
and something else. So that's all you could object to, but they still had to answer. You know what? Why were you wearing a green dress that day? I object to the form of that question. Okay, so noted. Why were you wearing that green dress that day? It was the only thing that was clean. Okay. So you can object to it, and then they say, you know what, Judge, before it comes to trial, I don't want that to come in. That was the only clean thing she had, whatever. That wasn't sufficient enough, So once they object, then they can go before the court and say, you know what, this is why we objected. We don't want this to come in. Oh yeah, you know what, that was a good objection, and yeah, we're not going to allow that to come in. All right. The civil trial. So the first step in a jury trial is similar to the first step in a criminal jury trial, the selection of the jury. For example, although 12 jurors are the numbers traditionally required, many district judges require only 6 jurors in civil matters. 1 or 2 alternate jurors may usually be picked in some of the cases of the original jury. So if one of the members of the original jury becomes sick or is unable to complete his or her duty, then the alternate comes in. Okay? So the 17 steps are: 1, the jury selection; 2, the opening statement by plaintiff; 3, the opening statement by the defendant, if they choose to do it at that time; 4, the presentation of plaintiff's case in chief, which is the calling of witnesses, which is that the further direct or redirect, no. I don't do it that way. You can ask some of the other reporters that come in when they do further. I just do re. Okay? Presentation of physical evidence, marked for identification, received in the evidence. 5, the plaintiff rest. 6, defendant's motion for directed verdict. Remember, they didn't prove their case, so we're asking for directed verdict. 7, the presentation of defendant's case in chief. The opening, unless he chooses to waive it. Calling of witnesses. Presentation of physical evidence. 8, defendant rest. 9, plaintiff's rebuttal evidence, which is he's going to rebut what the defendant brought in. Oh, well, okay, well, we didn't know he was going to bring that in. Now we're going to call other witnesses to rebut what he just put on. 10, defendant's surrebuttal evidence. 11, motion for directed verdict by either party. 12, closing argument by plaintiff. 13, closing argument by defendant. 14, plaintiff's argument in rebuttal if desired. So usually that's what they get. Now if you go sit in my court, my judge is like, anyone else have anything? Yeah, blah. Anyone else have anything? Yeah, blah. Anyone else have anything? Yeah, blah. Really? What are we doing? You know, and I used to tell him that. I used to kind of kid around with him about it, but I mean, it wasn't my place to really do it, but I used to kid with him. It's like, look, they go closing, closing, rebuttal.
That's funny.
Rebuttal, that's it. They just kind of used to laugh. But it's like, you know what, let them make their record. I've already made up my mind before they even make their closing statements or whatever, so it doesn't really matter. 15, jury instruction. 16, jury deliberation and verdict. And 17 is the entry of the judgment. Post-trial activities. 2 motions that occur after a trial by jury are a motion for judgment notwithstanding the verdict and a motion for a new trial. A motion for a judgment notwithstanding a verdict is a request by the losing party to set aside the verdict of the jury and have the judge rule in favor of the losing party. To make a motion for judgment, NOV, the attorney must have made a motion for a directed verdict at the close of all the evidence. So like say they come in and it's happened, where, you know, the jury comes in, well, you know what, we're asking for $10,000, you know, in monetary damages to this plaintiff. Okay. And the defendant was such a jerk on the stand. I mean, everybody just hated him. You know, and he was just such a jerk. So the jury comes back and says, you know what? $500,000 to the plaintiff. What? Yeah, that's what we're going to give them. $500,000. And they come in and they say, Judge, we, you know, and after it's all done, it's like, you know, well, you know, the jury can, the jury's decision was made. Then afterward, they could say, Judge, you know what? We want a motion for judgment notwithstanding the verdict. We were asking for limits on this policy, which is $10,000, not $500,000. We weren't asking for that, you know, and they weren't asking for that. So I mean, you know, so that's where it could happen. Okay. A motion for a new trial is made upon the assertion that something occurred during the trial that requires the matter to be tried again. Some examples of grounds for a new trial: the awarding of damages by a jury that are too large or too small, misconduct of an attorney during the trial, failure of the jury to follow the court's instructions, and newly discovered evidence. So any of those things can happen, you know. You know, like I was telling you, you know, they had 28 boxes of discovery, and it's like, you know what, we stipulate to 1 and 9, whatever. Well, all of a sudden he comes in with 27, and there was like a smoking piece of evidence in there that shouldn't have come in, that had nothing to do with it, and all of a sudden it taints, you know, the plaintiff side of the defendant side. Well, Judge, the jury already heard it. You can't unhear it. You can ask them not to, you know, not to take that into consideration, but if they've already heard it, so we're going to ask for a new trial because of that. Okay. Because it was attorney misconduct. We had stipulated already that we weren't going to get into that. He got into it. And now we got popped for $500,000 when all they were asking for was 10,000. Yeah. The losing party may also file an appeal to the court's ruling, provided that the proper time requirements are followed. In an appeal, the original losing party tries to convince the appellate court that the trial court committed a reversible error that entitled the party to a new trial. The appellant is the party who files the appeal and seeks to overturn the judgment of the trial court. The party who defends the appeal is the appellee or respondent. So it's not necessarily the plaintiff defendant. So it's not because it was the plaintiff that he's the appellant. No, it's either one. One of them lost or whatever, so they're going to appeal the case. So it could be either one. So now it's the appellant. Okay? Any questions regarding